Hello, my name is Michael DeSara, and I prepared this ACCC cheat sheet for September 2024. And if you've looked at these before, you'll know that what I do is summarise all the ACCC activities for that particular month. As you can tell, I'm doing this in December, so I've fallen a bit behind again. Hopefully, I'll be able to catch up in the next few weeks. And that image is pretty weird looking, I admit. But what I did, I asked ChatGPT to generate me an image showing cheating, and that's what it came up to. So came up with. So that's just explaining what that particular image is. Bit of background about myself. I'm a competition and consumer lawyer, and I run my own practice, DeSara Legal Consulting, and I've been doing that for about 18 years. And I help companies, individuals with competition and consumer law matters. I also do some expert consultancy work for various legal publishers on competition and consumer law. And prior to that, I worked at the ACCC for a few years, 15 years actually, and I worked in a number of areas, including enforcement and mergers. Now, that line is pretty similar to previous months. One court case, a couple of enforcement actions, some mergers. Probably a bit different in September. There were two guidelines issued, so I'll go through those, and also authorisations. And there was a heap of authorisations again. So in August and September, there were a lot of authorisations, inquiries and consultations, and some other matters. The big case in September was the case against Energy Australia, and this was commenced a few months ago, but obviously there was agreement made between Energy Australia and ACCC to settle the case, and Energy Australia agreed to pay a penalty of $14 million, which was signed off by the judges being appropriate. And this related to alleged breaches, or probably not alleged anymore, actual breaches of the Electricity Retail Code. This was brought in a few years ago and provides obligations or puts obligations on energy suppliers to provide their customers with additional information about various electricity offers. It's very prescriptive, and as you can see, there are a few mistakes made by Energy Australia. The first was that they failed to state the lowest possible price in their communications to consumers, but they also misrepresented the estimate annual price of its electricity offer for an average consumer. So that information all has to be included in the communications to their customers. And there was a further breach. They published 27 electricity offers that failed to state the difference between the reference price and the unconditional price. And you've got to express that one or two ways, either as a percentage of the reference price or the lowest possible price. So it's a very prescriptive code. It's aimed at giving consumers more information about electricity offers. It's very hard to compare them otherwise. And here you've got a very large provider, one of the largest providers in the country, getting it wrong in quite a lot of areas and for a fairly lengthy period of time. Like this is like a number of months. So the question that you have to ask yourself is, if Energy Australia are getting it wrong, how many other companies are getting it wrong as well? So hopefully there's a wake-up call for the whole industry to really make sure this information is provided to consumers accurately. The enforcement action, the first one was Honda, and they've had a couple of cases in the last few months. This was an infringement notice, so they got hit with an infringement notice for $780. And this related to a breach of this special scheme called the MVIS scheme, the Motor Vehicle Service and Repair Information Sharing Scheme. So that's a mouthful, obviously. And this was something that was brought in a few years ago to sort of facilitate the provision of particular diagnostic and technical information from the manufacturers to independent repairers. Because in the past, a lot of independent repairers didn't have access to the information, so they couldn't fix your car. And that meant you had less options as a consumer. So this scheme was brought in, and it creates a positive obligation of manufacturers to make this information available at sort of reasonable prices so that you can get them to fix your car. And the problem here was Honda did supply the software, but only by yearly subscription. So obviously that's going to be quite expensive. And if you're not fixing many Hondas, it's maybe not justifiable to spend money on a yearly subscription. And really, they should have given independent repairers the option of buying less expensive subscriptions daily or a monthly basis. So again, this law has been around for a while, and you've got a very big provider of motor vehicles getting it wrong. And again, you've got to say to yourself, how many other manufacturers may be getting it wrong and not meeting their obligations? The biggie in September was the action by the ACCC against Woolworths and Coles, and they commenced proceedings against both companies, but pretty much for the same conduct. It's sort of known as was now pricing. So you have a previous high price, and then you sort of say it's discounted to a lower price. And there's quite a bit of guidance around the way this works. But the allegation the ACCC made was that there was a price that these products were sold at for quite a lengthy period of time. Then the price was spiked up considerably, so increased for quite a long period of time, kept at that higher price for the minimum accepted period, which is generally thought to be 28 days, and then reduced. And I guess the Woolworths promotion is prices dropped, and the Coles promotion is down promotion. So it's a case of misleading deceptive conduct that the price was increased to an artificially high price, which wasn't the usual market price, and then reduced. And so consumers are thinking they're getting a much bigger saving or getting a saving off the usual price, and arguably they're not getting any saving at all because the price was not the usual price the products were sold at. So the ACCC has taken this case, talking about price rises of 15% for brief periods and then being placed in the relevant discount categories. And I guess there's also a concern that they both did quite similar conduct, but it relates to different products. So there's quite a lot of important products for consumers that have been subject to this particular alleged misleading deceptive conduct. And as you can see, there are 266 products for Woolworths over a 20-month period and 245 products for Coles over a period of 15 months. And ACCC went through and listed the products, and these are pretty, I guess, they're not obscure products like pickled herrings and things. They're pretty mainstream products like Arnott's Tim Tams, Doritos salsa. You've got Moccona coffee. Also got Oreo cookies, Palmolive dishwashing liquid, Sprite soft drinks. So they're pretty major products. And then for Coles, you've got Arnott's Shapes. That's the big seller. Bega cheese, Cadbury chocolate, Coca-Cola, Colgate toothpaste, Kellogg's. You've got all these Rexona, Palmolive. These are very high-profile brands which a lot of people buy. So it'll be really interesting how this case pans out. One thing that's interesting about this case is in the actual originating documents the ACCC filed with the court, there's actually a suggestion that they may be able to make a contribution to various charities that support people who have trouble affording groceries. So there might be an option for Coles and Woolies to ramp up a very big donation to charity and argue with the ACCC about paying a small fine, and therefore, I guess, getting some positive press for donating a lot of money to charity and less negative press for paying a very, very large fine. So it's interesting that the ACCC sought that at the very beginning of the case, and I think it does give Coles and Woolies a bit of an out if they wanted to settle this case. I think they should settle it. I think they're going to lose if they run it. I can't see there's many arguments. It reminds me of the Qantas case where they ran these sort of elaborate arguments initially about how they were going to get out of trouble, and then those arguments fell away very quickly and they settled. It's the same thing here. Coles and Woolies could argue some technical arguments, but I don't think they'll ultimately be successful. In mergers, the first one is the Optus TPG deal, and this was obviously the replacement deal for the Telstra TPG deal that was put to the ACCC and rejected, and then appealed to the Australian Competition Tribunal and rejected. And I think it was suggested, I think at the tribunal level, that maybe TPG should look at Optus instead, and that's what they've done. So Optus and TPG have come to a deal, and effectively ACCC said it's fine. There are 3 agreements, and it really is sharing various networks and services in regional areas. So in regional coverage areas, Optus will use TPG spectrum to supply mobile services, and then Optus will provide TPG with network services. So that means TPG will close down its network services in regional areas because it won't need it. Clearly, they'll keep competing in the metropolitan areas, and the ACCC found some public benefit here. TPG will provide better coverage in regional areas. Also, there'll be probably lower costs in providing the services, better choice for regional consumers, and also a view that it might facilitate Optus's rollout of its 5G network. So ACCC has identified a lot of potential public benefits. The Stockland Superline merger, I looked at it a couple months ago, and this was initially a concern for the ACCC. It was an area that I knew nothing about. Master plan community projects, got no idea what that is, but it seems that Stockland and Superline were very close competitors in this particular market of residential master plan community projects, and they were proposed to buy Lendlease's portfolio of 12 such projects, and that was a big concern because they were head-to-head competitors. So under there's an undertaking being put forward to the ACCC accepted whereby the merged firm will sell one of the master plan community projects, the one Forest Reach down in the Illawarra region. So obviously it was thought down there that there wasn't really much competition post-merger, and so what needed to happen was for the merged firm to sell that particular master plan community project to somebody else. And clearly this is going to be interesting to see who picks it up, what competitor there is in the market to buy this particular project. Olam Namoy Cotton, this is part of a fairly involved series of merger proposals. The other company that's trying to buy Namoy Cotton is Louis Dreyfus, and they sort of got in first, and so they're a bit of a step ahead of Olam, and they've actually been identified as having some competition issues. They've proposed some divestitures, and the ACCC has come back and said, yes, with those divestitures, we'll let you buy Namoy Cotton. The big thing here is who does Namoy Cotton want to sell itself to? Obviously, the company that's going to offer them more money. So even though Louis Dreyfus has approval, if Olam offers more money, they will prefer to sell to them. The problem is Olam was behind Louis Dreyfus in the scheme of things, and so now they've put forward a divestiture proposal, which the ACCC is seeking views upon, or seeking views on, and if this is accepted by the ACCC, both Olam and Louis Dreyfus will have a clear path forward to buy Namoy Cotton. So here the concerns were about cotton ginning and also cotton classing services. They believe that there would be a lessening competition in those two markets. So what Olam has done, it's offered pretty similar undertakings to Louis Dreyfus, effectively sell its Queensland cotton gin at Weewar, and also, divest its Queensland cotton gin at Weewar in New South Wales. It's a bit confusing. Queensland cotton gin at Weewar, anyway. And its 20% share of ProClass, which is a cotton classing service. So if that's accepted by the ACCC, then they can, I guess there'll be a bidding war between Louis Dreyfus and Olam for Namoy Cotton. Then the first of the two guidelines, and this arose in relation to the ACCC Telecommunications Infringement Notices Guidelines, and there was some legislation passed to give the ACCC more power to issue, I guess, on-the-stop fines to various telecommunication providers who breach carrier separation rules on the Telecommunications Act. So effectively, the legislation wants there to be a separation between different levels of the system for providing telecommunication services. And if companies do breach these rules without getting an exemption, then the ACCC can impose quite large fines. So you can see recent legislative amendments have given the ACCC the power to issue these infringement notices. The penalty is going to be up to $10 million per contravention for non-compliance, and they can obviously take court action in more serious cases. And I guess the main thing here, you can't be involved in super fast broadband network and also retail services unless the ACCC gives an exemption. So if you breach the rules without exemption, you can get hit with an infringement notice or taken to court. The second one relates to guidelines for authorisation of conduct non-merger, and this is really to clarify the way that ACCC approaches interim authorisation. So often companies want to start talking before all the benefits and all the details of the authorisation are being worked out, so they get a short-term protection from, getting sued under the relevant legislation. And there have been a real lot of these in recent times. Probably during COVID, there was a real need for very quick authorisations of collaborations between competitors, and the ACCC is very good in terms of looking at those and approving them. But since COVID sort of passed, there seemed to be a lot of interim authorisation applications still being made, and it was important for the ACCC to provide some guidance. And I think what they're saying in this guidance is, like, you've really got to give us the proper information if you want interim authorisation. If you don't give us enough information, we're not going to give it to you. You can't just skimp on the information provided. Also, we're not going to give you one quickly unless it's exceptional circumstances. So not only do you have to give the ACCC all the information they require, but you've got to explain why it's exceptional, why it's really needed to get this very quickly. So I guess this is well worthwhile to give companies and their practitioners better guidance on these issues, because my understanding is people have been probably pushing the boundaries of what they really should be entitled to getting, and this I guess sets the boundaries very clearly, and so people can't just push the ACCC to make these urgent decisions where it's not really justified. Now, the authorisation, I said there are a huge number of them, so I won't go through them in a huge amount of detail, but the first one was the Thai Stewardship Authorisation. This has been around previously and it's been reauthorised, and effectively it's a way of seeking to reduce the environmental effects of tyres, in Australia. And effectively, there's a levy charged on every tyre which goes to this organisation, the TSA, and they use it to explore different projects to, I guess, recover tyres and potentially recycle them and do various things like that. So as you can see, since it's been established, $9 million has been obtained through the levy and used for various projects. The Pilbara regime, I've never heard of this before, but apparently this is in relation to the Northwest interconnected system. And there was authorisation, I think it was in place earlier, it's been continued. And this is effectively allowing the various groups in that area, competitors, to work together to maintain or improve the safety, security and reliability of the system. And that includes exchanging information, planning or implementing requirements relating to either system security measures, outage coordination, technical connection standards. So it's probably to be extra careful. You've got competitors meeting, talking about a lot of issues, probably talking about a lot of confidential issues. There's always a risk that might be seen as cartel conduct. So this is a protection they're allowed to do without really having any fear of getting into trouble. Now, the Southern Waste Solutions matter was a strange one. It was an authorisation seeking approval to design, build and operate a contained organics waste facility in Copping, Tasmania. And what the ACCC has done is it's actually not allowed the authorisation to go ahead, primarily because it didn't see there were any public benefits arising from the proposal. And so if there's no public benefits, it shouldn't be authorised. So that was, a concern obviously for the parties. They're seeking to build something, but the thing is, if you can just do it regardless and without the need for authorisation, then the ACCC shouldn't be granting authorisation. And I don't actually know why they even applied for authorisation here. I don't think they actually needed it. So it's good the ACCC is saying no. The ACCC shouldn't be exercising that very significant power where there are no public benefits. Electricity distribution. This is authorising Victoria's 5 electricity distribution network service providers to continue to operate a scheme which requires civil contractors performing particular underground civil works involving electrical infrastructure to meet certain accreditation standards. So this is again driven by safety and I guess quality. They can all agree on certain accreditation standards with these civil contractors have to meet, and obviously imposing a higher level of highest standards on these contractors. And I guess if it wasn't for this authorisation, I guess there's a possibility that some civil contractors might drop their standards, which might compromise obviously quality, but also could compromise safety. Dental practices. This was one which I don't quite know why they authorised it. Australian Dental Association sought an authorisation to allow their members to price fix effectively if they were working in a shared practice and one member was a member of the ADA. And I just can't see allowing these members to price fix is a public benefit. And the ACCC found some public benefits, which I've listed there. I just don't understand this. Patient certainty of price. Well, I think patients like lower prices, and so if you're going to be setting prices, they're going to be probably higher than the market price. Access to practitioners. So maybe if you can't price fix, you're not going to provide the service. Practitioner cooperation, improving efficiency in the provision of quality and dental services. And I think that's right in terms of the theory of cartel conduct. I don't know if really the cartel conduct is often a way of not having to worry about your efficiency. and supporting flexible working arrangements. It just sounds really weird, this one. I just don't know why they authorised it. But anyway, they must have made a good case to the ACCC, but I can't see this has got any public benefit. Health insurance. They grant authorisation for 5 years to St Luke's Medical and Hospital Benefits Association, so a health insurer, to enter into and give effect to specified price capping provisions in agreements with dentists, again, who participate in St Luke's Dental Partner Provider Network and who are in the same local catchment areas as St Luke's own dental practices. So obviously St Luke's has its own dentists, and other people provide services to, I guess, St Luke's. Other dental practitioners provide services. And so it wants to be able to basically set the price for all those different groups. Again, I really can't see a public benefit here. Like, at the end of the day, clearly the price capping suggests that prices are going to be kept lower than they might otherwise be. But, and that, I guess, is a benefit to the public. But I don't quite understand why the ACCC should be agreeing to an arrangement that caps prices. It doesn't seem the kind of thing that authorisation is all meant to do. The next one, cash and transit. This has been a very tortuous history. This was Armaguard got together with Prosegur, I think it's called, the Spanish company, and merged. And then no sooner had they merged, and there was an admission that they were going to go broke, and there wouldn't be any cash services in Australia, which is problematic because before the merger there was two, and after the merger there was one. So I guess what's happening now is there's a lot of organisations which need cash: banks, Australia Post, supermarkets, and if the cash and transit business of Armaguard closes down, there's going to be no cash. That's a pretty dramatic consequence. So the ACCC has authorised ABA and these different retailers to get together to try and work out some way of solving the problem. It allows the parties to collaborate and prepare for any suspension or disruption of cash and transit services. So Armaguard is actually owned by Lindsay Fox, and I don't know, it's a failing business. There's not as much cash, and unfortunately the only way I think it's going to work is if some of these retailers and banks pump money into it to keep it afloat. So I don't know, if you can't run a business, getting your customers to fund you is a pretty humiliating, I think, approach to running a business. But anyway, it doesn't seem to be bothering Linfox too much that they're getting their customers to stump up capital to keep them going. Graduate medical. I remember I looked at this when I was at ACCC about 15 years ago, and this was some sort of arrangement whereby I guess the medical students who were coming through university or coming out of school were allocated to various universities, and the idea there was to, I guess, spread them around a bit, because the risk is they all apply to go to one particular place, and I guess the cost of running medical schools is quite high. So there's this agreement to allow the graduate entry medical school admission system to effectively manage the application process from students to go to medical school. So I think there are some significant public benefits associated with that. Infant formula. Now, this one was given the kiss of death a while ago because there was a code called the Market in Australia of Infant Formula Manufacturers and Importer Agreement, the MAIF agreement, and it had various provisions in it. But then, as you can see down the bottom there, the Department of Health and Aged Care commissioned an independent review of this particular agreement and found that it was no longer fit for purpose. So it was sort of a dead duck at that stage. They went to the ACCC to try and get authorisation to keep it alive, but the ACCC now is proposing to deny the authorisation. So the Infant Nutrition Council will no longer have a code that's authorised by the ACCC. And so I guess the main thing here is obviously the Infant Nutrition Council's maybe pretty desperate to keep this thing going. But what's likely to happen, as you can see down the bottom there, effective government regulation of infant formula marketing would likely result in public health benefits. So the government said, you've tried an industry code, hasn't worked, hasn't achieved the right outcomes, so we're just going to legislate here. And so that's inevitable. I guess what could potentially happen is if the ACCC follow through and do deny this particular authorisation formally, Infant Nutrition Council could challenge that in the Australian competition tribunal and get that decision overturned. But I think it's unlikely. I think once the government says they're going to legislate in an area, I think the self-regulatory codes are pretty well finished. In inquiries consultation, a few of these. The first was the regular Measuring Broadband Australia report. Some interesting findings that there have been significant improvements in NBN's fixed wireless plan. Speeds have been going up. And somewhat strange outcome here, the average fixed line speed now exceeds the maximum plan download speed. Doesn't seem to make sense. How can the average exceed the maximum? So obviously you're saying it's like 50 maximum, but people are getting more than 50 megabytes per second. So I guess that's showing that NBN's networks have been improved and are now performing to a very high standard. Insurance, this is also an issue. Third, insurance monitoring report. This arose in the context of problems in the north of Australia from getting insurance much higher and much more difficult to get particular types of insurance. So the government's pretty well stepped in and created this pool, this reinsurance pool, to try and get insurers involved. And as you can see, it's had a positive effect. Cyclone Reinsurance Pool has begun delivering lower premiums to some consumers, so that's good. But then the bad news is the savings generated by having the pool have actually been offset by other issues, external factors such as hardening of global reinsurance markets. I don't quite know what that means, hardening, but anyway, extreme global weather events and price increases of building materials and labour. So even though it's improved outcome, made insurance available, it's still not as cheap as really it needs to be for a lot of these different groups who need this insurance. Petrol, the quarterly petrol monitoring report. This showed that the average petrol prices in the 5 largest cities decreased in July and August, and it's all linked to the international refined petrol benchmark prices. So I guess the main thing, if the international refined petrol benchmark goes up, our price is going to go up. If it goes down, our price is going to go down. And I guess the good thing about this is if, say, the international refined petrol benchmark prices went down and our prices went up, you'd be saying, well, what's the cause of that? Is there something funny going on? Is there a cartel going on, or some other factor? So I guess this gives people peace of mind that there's nothing untoward happening in the Australian market. Then the gas inquiry report came out. This is just so fluctuating. It's up and down like a yo-yo. Gas supply surplus in Australian East Coast market is forecast to be between 12 and 27 petajoules in the first quarter of 2025. Now that's not good, because you can see from the next paragraph the forecast for this particular period earlier was between 26 to 35 petajoules. So what's happening is there's going to be less gas available for local users in the beginning of next year. That's a problem. The reasons for it, I don't understand the first reason, reflects LNG producers' reshaping of export cargoes. I don't quite know what reshaping is, but obviously more gas is going overseas, and these fellas need to keep more gas onshore, or else they're going to be looking at some pretty stiff regulation. I think that's the risk they run. If they keep selling too much gas overseas, the government's going to step in a lot harder than it did in the past. Now, the big inquiry consultation was the ACCC's report. I got 2 cameos there. That's interesting. Effectively, there was the interim report put out, and the ACCC made some pretty obvious conclusions. I guess the first was supermarket retailing in Australia is an oligopoly, with Woolworths and Coles accounting for 67% of the supermarket sales nationally. That's not a big surprise. I think we all knew it was an oligopoly. There's a lot of research coming out that they tend to copy each other's prices quite a lot. Aldi is a very significant competitor, but it's been here for quite a long time. It's generated 9% market share, so it's very hard to really grow. It has a particular business model, which is to sell a much narrower range of products than Coles and Woolies, so not really a full service competitor, Woolies and Coles. It is used more as a complement, I think, to Coles and Woolies, and it has no intention of entering certain markets due to the logistics. So forget Northern Territory, forget Tasmania. So it's not going to those markets. Metcash has been going backwards over the last few years. It's really struggling. I think what's happening, a lot of its guys are failing to be able to compete, or they're getting picked off. Some of the bigger stores are getting picked off by Coles and Woolies, and so it's a declining force in the market. There's no doubt about that. And their prices are significantly higher than both Coles and Woolies. Clearly, the bundle of products that ACCC looks at has Aldi as the cheapest. The price of typical basket of goods has increased by more than 20% in the last 5 years. That's a very concerning conclusion. I guess Coles and Woolies would probably challenge that conclusion, but there's really no explanation for that increase. It's got to be. Sometimes you see increased prices from various suppliers and things like that. That just looks like it's a lack of competition and prices going up. The majority of respondents in low-income households are spending more than 20% of their net income on groceries, which I think maybe more than that actually. So I don't know how reliable that is. And I think it's just not low-income households. I think a lot of people are spending quite a lot of money on food nowadays. Many consumers report having lost trust in supermarket pricing. Probably not a big surprise there, particularly with that was now case. Suppliers report facing unfavourable terms. This is interesting because there's been a grocery code for a few years, and it's sort of showing that the supermarkets don't have many problems with the suppliers. But then when there's a sort of more anonymous sort of survey, the reports are that there's a lot of problem between suppliers and supermarkets. So that just, I guess, explains how scared suppliers are of Coles and Woolworths. And there's significant barriers to expansion. That's obviously the case. There's been some allegations of land banking, preventing competitors from getting access to big sites. So that's a big issue. And clearly the logistics of supplying some markets is very hard. The fact that Aldi has stated publicly it's not going to go into Northern Territory and Tasmania suggests that even they can't overcome the logistical barriers from entering those two markets. Back to one cameo now. There was this interesting thing, the Bathurst lecture. I haven't heard of it before. I don't know. It might be new in relation to the former Chief Justice Bathurst. So it's a lecture put out by the New South Wales Bar Association, Bathurst Lecture in Commercial Law, and the one in 2024 was delivered by Liza Carver, who's Commissioner. And it's very interesting actually because this is the 50th anniversary of the Trade Practices Act. And so there's a bit of celebration going on. I'm the general editor of the ABLR. We're putting in a special edition to commemorate that as well. So this speech by her really does summarise a bit of the history of the Trade Practices Act. So it's well worth a read, actually. It's a good speech. Also, the Digital Platform Regulators Forum. That's a bunch of organisations, Privacy Commission, also ACMA, various groups, and they're part of this forum. And they issued a working paper which sounds interesting. I'll say it sounds interesting because I haven't read it myself. Examination of Technology, Multimodal Foundation Models, and it looks at generative AI and basically the way it operates, and particularly the impact on the regulatory roles of each of the members. So I'll be reading that sometime, a bit of holiday reading. I'm sure it's very interesting, so that might be something you want to look up. The final thing the ACCC issued a press release, probably the first time I've seen this, is the new Workplace Equality Index, and they were awarded the bronze tier status. So that means that obviously it's quite a diverse organisation on a number of the measures. So they're pretty proud of that, and that's a good outcome. It's important that regulators be diverse in the people that are working there. So just a commentary, the Woolworths litigation is very interesting. Actually, Woolworths and Coles litigation is going to be very interesting. I do think they're going to give up. I think it's too dangerous to litigate this case. I think they'd lose the case because I think it's misleading, quite apart from anything that anybody said about the way to do was now pricing. People believed that they were getting a discount of what the usual price was, and it wasn't the usual price, the usual market price. It was a increased price. So I think they'd lose that. I think they've got a good out. They could just throw a lot of money at the charitable side of the settlement and argue strongly to pay a small fine. And ACCC is going to have a hard time saying no to that. I think if you throw a couple $100 billion at a charity and you say I'll pay a $10 million fine, ACCC is going to be very reluctant to say no to that. So they both got a way out. Coles is probably being the more bolshy when it comes to fighting the case. Woolworths are being more circumspect, which is a dead set turnaround from when I used to be at the ACCC. I did sue both companies back at the ACCC, and it was probably the reverse. Coles were very circumspect and Woolies very bolshy, but things have certainly turned around in the last 20 years. But I think they'll settle. Energy Australia, that's a sensible case to settle. It's pretty clear what the law says. The thing that it does suggest is that a lot of these retailers are going to be getting this wrong, and they really have to pick up their act. Like, they're big companies, they've got a lot of resources, they've got to get this right. It's not to use that old expression. It's not rocket science. It's very simple. Mergers, divestitures. It's clear that many mergers that look to raise concerns can get over the line with the sale of a few assets. And that's the whole idea. A company will acquire a substantial degree of market power. You sell some assets off, still going to have market power, but not a substantial degree of market power. And so that's just basic economics. The thing that I find somewhat strange is the reaction to the proposal that breaches of Section 46, misuse of market power provision, shouldn't be subject to a divestiture order. Because the logic is very, very similar to the mergers area. If a company has acquired market power, a substantial degree of market power, and has used that in the market, then there's no point just fining them. The sensible approach is to actually take some of the market power away, force them to sell some assets, remove the substantial market power that they have. But I guess Albanese's come out, and I think he said something a bit off the cuff, saying that apparently divestiture orders in the context of Section 46 and misuse of market power is the kind of thing you'd see in a communist state. I didn't really understand that comment, but unfortunately he made the comment, and all the different ministers are queuing up behind that comment, and it seems like divestitures for misuse of market power are really not on the table as far as the government's concerned. Lots of authorisations. I think maybe the ACCC is reporting on more of these than they did in the past. I don't seem to recall so many. I think the good thing is they're saying no to a lot of authorisations where the public benefit really isn't there. I think there's a few are still slipping through that don't have much public benefit. And I think the best thing is, if there's not real strong public benefit, just say no. It's a really, really important power that they have, and they shouldn't use it in questionable cases. Supermarket inquiry is going to be really interesting. The interim report's come out. The ACCC is supposed to report in the beginning of 2025 with some more solid proposals. And I think the big issue is, are they going to recommend divestiture in relation to supermarkets? It'd be a brave call. And I think economically, it sort of makes a bit of sense. If these guys have too many stores in particular locations not competing, then they've got to divest them. And who's going to buy them? Well, Aldi might buy them, or Costco might buy them, or a new entrant might buy them. But clearly, if organisations have too much market power arising from particular stores, then divestiture makes perfect sense. But I think it'd be a brave call for the ACCC to recommend that. And so I don't know. I doubt they're going to recommend that in their final report. So that's all I had. It's been a big month. So hopefully that's a helpful summary. Probably saved you a few hours of reading all these press releases from the ACCC. If you have any questions about any of this, feel free to give me a call or drop me an email. Bye-bye.